All right. What I'll do is I'll follow your agreement, set the bond at $10,000. I'll do the referral to Center for Healthcare Services because obviously.
Hold up, did the judge just say he's not taking what they're saying as true, but is still setting bond terms based on it? That's a classic example of a judge playing it safe, legally protecting rights, while making sure the public isn't at risk.
And I'm not taking what they're saying is true, but you shouldn't drive. Court is calling 2024 CR 2831 State versus Brandon Diaz. Could I have parties announced?
Attorney for the state of Texas.
Martin Guerra, attorney for Brandon Diaz.
And are you Mr. Diaz?
Yes, Your
All right. This defense has requested a bond. He's entitled to a bond because it's a deferred adjudication.
Okay, here's where the legal gears start turning. The judge can't just rubber stamp a bond without knowing what the allegations are. So now we're entering the part where the real reasons come out. Watch closely.
My understanding is that you all have made an agreement for $10,000. Is that correct?
Honor.
Does anyone have the allegations in the motion to revoke
Your Honor,
so that I can set appropriate bond conditions? Oh, okay. All right. Thank you.
yeah.
All right. And what is the alleged?
Reckless driving crime.
Ah. Oh, thank you.
Your Honor.
All right. So I'll set your bond at $10,000.
That moment of vulnerability, Diaz says he has anxiety, but hasn't been diagnosed. It's subtle, but this can influence how the court considers referrals for mental health treatment. Mental health and legal accountability are deeply intertwined here.
All right. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right. You can lower your hand. State your name for the record.
Brandon Edward Diaz.
All right. So have you used any type of drugs in the past? No marijuana, no alcohol, nothing?
No.
All right. Have you ever been diagnosed with any mental health?
Notice how the judge doesn't just go by what the defense says, they want to double check with probation. That's the system trying to verify, not just trust. But here's a question for you. Should courts rely more on verified facts or trust defendant history in cases like this?
That I'm aware of, I know that I have anxiety, but never been diagnosed with it.
All right. All right. What I'll do is I'll follow your agreement, set the bond at $10,000. I'll do the referral to Center for Healthcare Services. If you go there and they discover that this is normal anxiety, it's just maybe anxiety about your legal matters, then they may decide something different for you. But just to be on the safe side, I'll do a referral for that.
Okay, thank you so much, Your Honor.
You're welcome. All right. So we can go off the record. So is this going to be a contested?
I need to speak to the prosecutors over in the county court first, Your Honor. I'm just getting discovery on that new case.
Additionally, Your Honor, I guess while we're off the record, they were just asked as part of his bond conditions, the victim that was involved in the original injury to a child charge, if there was and no contact order, that still be in place.
Well, let me see.
And actually, that's the
Moment, Your Honor.
Sure.
I don't think there's a need for that. He does have regular contact with his children, his child.
Well, what
There's not a no contact order as a condition of probation.
All right. Well, what I can say is
Asterisk. This is important. Even though there's no official no contact order, the judge confirms, Diaz completed a parenting class, and the injury wasn't intentional. The court's balancing act between protecting children and preserving family contact is always a tightrope.
During, and I think I'm very thorough when I'm setting conditions. And if there would have been an issue at the time for him having contact, I would have had it in the conditions of probation. And those conditions are not in his conditions of probation. I'll have probation double check just to be sure though. Bashan, on this case, do you know if he has a no contact order in place with the complainant? I don't think there is, because if I remember this.
The classic. Set a contested hearing just in case. These resets keep the wheels of justice turning, but let's be real. How often do you think these actually go? Contested versus quietly settled behind closed doors?
Case correctly, the injury wasn't, it was an injury, but it wasn't
No, Judge, there's no.
done intentionally.
Right.
No, Judge, there's not a no contact order in place.
Okay.
And he has completed his parenting class.
Yes. So it was, the injury had to do with
There's a discovery clause.
evading. Yeah. I will tell you this, but what I am going to add to his conditions of bond is I'm adding no driving. Because obviously, and I'm not taking what they're saying is true, but you shouldn't drive.
Yes, sir.
All right. Then, Ms. Ferguson,
Yes, ma'am.
can you put this for a contested hearing the week of June 23rd? And then, counsel, if it turns out it's not contested, that's fine.
Okay.
All right, so it'll be June 24th. And if it's not going to be contested, counsel, if you'll let probation know before that date.
Yes, sir.
All right, Ms. Ferguson, he needs a reset form for June 24th. All right, thank you.
Thank you. Thank you.